Judge, welcome.
Thank you.
You are probably the least productive member of your district court, isn't that right?
Well, I have not considered myself in those terms, Senator.
Well, let me explain what I mean. You have 125 motions pending that you've declined to decide.
Well,
Let me finish. That's more than any other district judge in the entire Seventh Circuit. In fact, you rank seventh highest nationally, do you not?
I am not familiar with those statistics, Senator Kennedy.
You haven't looked?
I did look in preparation for this hearing, but I didn't compare myself to others.
You haven't seen that you ranked the seventh, the worst in the country in terms of making decisions?
You are the first to tell me this. And I think for me, I stress the quality of my decision making. And as I explained, I came on, I was the first district judge to come on during this administration.
Yeah, but so were all the others. I mean, there have been 68 district judges confirmed in the 117th Congress. In terms of motions pending for more than 6 months, you rank number 3. You all came on at the same time. You all had the same problems with COVID. You're the third worst. You really think of all the other district judges in the Seventh Circuit, you're the one that ought to be promoted based on this record?
Senator, this is something that I've discussed with my fellow judges. Many of us new judges from...
Not you said you'd never looked at these statistics.
I haven't, these particular statistics I am not familiar with. But in terms of new judges, both from the current administration and the former administration, we are quite a collegial bunch, and oftentimes talk about the pressures of a new judge and the way reassignments work in our district, which is that you get, for example, 300 cases.
Yes, ma'am, I understand. I'm familiar with the procedure in federal court. Here's what I'm trying to understand. Why is your record so bad?
Well, I don't view it that way, Senator. When I look at the quality of my decision-making, the feedback that I get from parties,
Of course parties are not going to criticize you. They want you to rule in their favor.
I understand, Senator Kennedy.
I mean, that's just the way it works. Help me understand why you have such an abysmal record in moving cases. I mean, it costs a lot of money to litigate, and people are paying lawyers, and time is money. And of all the district court judges in the Seventh Circuit, you're the worst in terms of moving cases. Why do you think you deserve to be promoted over all of those others?
So, Senator, again, I'm not familiar with the statistics, but I stand by my record and that I give parties what they need. I think, I am regularly in my courtroom. I am regularly issuing decisions. I just came on at a very difficult time where there was a backlog in the courts.
So did everybody else. Let me ask you, when you were a partner in your law firm, you volunteered to write a brief on behalf of the Brady Center. You wrote the brief, and this is what you said. You volunteered for this. You weren't being paid. Is that right?
This was a pro bono case that one of my partners brought in, yes.
You said, quote, assault weapons may be banned because they're extraordinarily dangerous and are not appropriate for legitimate self-defense purposes, close quote. Tell me what you meant by assault weapons.
Thank you, Senator Kennedy. Just to clarify there, I was local counsel. Our Supreme...
Yeah, but you wrote the brief. Tell me what you meant by assault weapons.
Senator Kennedy, actually, I did not write the brief. The brief was written by,
You signed the brief, though, didn't you?
correct, I signed the
When you
brief.
sign a brief, you're testifying to the court that everything in it is true, right?
Yes,
Okay. So they're your words in terms of the court, right?
well, you're correct, Senator Kennedy. I would never
So tell
sign.
me what you meant by assault weapons.
So I am not a gun expert, and at the time, that brief, I think, was about 10
You
years.
were giving the court advice about, say, ban assault weapons. What is? You told the court you were an expert. Just tell me what you wanted to ban.
Senator, sitting here today, as I said, I did not write that brief. I was local counsel.
Sign the brief.
I understand. At the time
Tell me what you wanted to ban. That's all I want to know, Judge.
I don't remember the exact definition of assault weapons in the ordinance that was at issue.
So you submitted a brief to an appellate brief. You signed it, and you don't know what. And you said abolish assault weapons, and you don't know what you wanted them to abolish.
Senator, at the time that I signed the brief, I read the brief because our Supreme Court required an Illinois bar member to sign the brief. I was not responsible for researching the content.
You were responsible for the brief. You signed it.
Absolutely, absolutely. And sitting here today, I do not remember the characteristics of that were cited in the ordinance for the assault weapons ban. It's not an area of practice that I have specialized in. I'm sure 10 years ago I could have answered your question.
And
But
Judge,
sitting here today,
you think
Senator,
you
your
deserve to
time
be
has
promoted?
expired.
Judge, welcome.
thank you.
Appreciate you being here. I want to talk to you about your relationship with demand justice. And during your last confirmation process before this committee, you said in response to a question for the record that you've spoken with Demand Justice's co-founder, Chris King, and I'm quoting you, a couple of times about the judicial nominations process, end quote. Do I have that right?
Yes.
Okay. I've looked at the positions that Demand Justice has taken, and one of their priorities has been to expand the Supreme Court. So did you speak with Mr. King about expanding the Supreme Court?
No, Senator Blackburn. My conversations with Mr. King were limited to getting advice and guidance on how the nomination process worked. It was quite opaque to me at that point, and so he provided
All right.
guidance.
Do you support increasing the number of justices on the Supreme Court?
That is a matter that I am precluded from opining on under the canons. But I think if you look at my record, I've never taken that position.
I don't think you're precluded on giving an opinion as to whether or not you think that the Supreme Court should be expanded. And Demand Justice has suggested that adding 4 justices would bring, and I quote them, restore balance and integrity. So do you think that there's a particular number of justices that should be added to the Supreme Court?
Senator Blackburn, I have never taken any position on this. I don't think it's appropriate for me to opine on it.
Okay, Demand Justice claims that the Supreme Court is, and I'm quoting them, unethical, unaccountable, and out of control. Do you share that assessment?
Senator, I don't have a relationship with Demand Justice. I've only spoken to Mr. King on a couple occasions several years ago. I'm not familiar with their positions, but I don't associate myself with those.
Obviously, you respected him, or you wouldn't have called him and gotten advice from him. So that is what concerns me, that you would go to a far left-leaning group to get advice on how to come before the Senate Judiciary Committee. I want to, Senator Kennedy talked with you about your ranking, and you are, as he told you, number 1 at having the biggest backlog in the 7th Circuit, and you're number 7 nationwide with outstanding motions. And the thing, as I looked at this, Judge, what is very curious to me is how you're so out of step with the other district judges as far as managing your time and moving cases forward and actually making decisions. I looked at the alarm detection systems case, and you've had a fully briefed motion since September of 22. And then the Palladino Wells Fargo case you've had since November of 22. So I understand how time-consuming the work is. I understand, and let me tell you, we do a lot of reading. We do a lot of prep work for our hearings. But I find it interesting that when you have a fully briefed case in front of you, you cannot come to a decision. So what hinders you from being able to arrive at decisions when you have everything you need to make the decision?
Thank you, Senator. I wouldn't say that I'm hindered in my decision-making. In fact, if you look at my record, I am a fan of ruling on the record. And so I've done decided many motions on the record at hearings over the course of several hours. So I'm not hindered.
District Judge, let's talk about that, because I went in and looked at your record, and I noted the fact that you've only presided over one civil trial to verdict in your nearly 2 years on the bench. One trial, just one. And that, combined with the fact that you had tried only 3 cases when you were in private practice, leads me to question your fitness for the court. So how can you expect us to confirm you to the circuit court when in 2 years you've presided over one civil trial and your backlog is larger than nearly everyone else? What would qualify you?
Senator, I would look at the quality of my decision-making.
Other judges find a way to do expediency and quality of work. Thank you, Judge. Thank you, Mr. Chairman.
Thank you, Senator. I believe Senator Lee is next.
Thank you, Mr. Chairman. Thank you, Judge Maldonado, for being here. When we look at the work of a federal district judge, it's a busy docket. One has a lot of motions to follow and to stay on top of. Some of the motions that end up taking a lot of time are on the civil docket side of things, motions for summary judgment. In your view, what's worse, when you've got a close case, to grant a non-meritorious dispositive motion or a Rule 56 summary judgment motion, or to fail to grant a motion for summary judgment where it is warranted? In a close case, which one is worse, or is either worse?
Thank you, Senator Lee. So I am very careful with motions for summary judgment because I respect the role of the jury. And I think it is rather arrogant for me to decide there's no disputed issue of material fact. And so I inherited, tens and tens of motions for summary judgment, and I take those very seriously because I don't want to take someone's day in court away from them and usurp the role of the jury. Sure. So those are the most time-consuming motions that I have before me. And just to clarify, when I received my reassignment, many motions that I received were from 2020, 2021, and so I had to triage and have a pipeline and decide the oldest first, and that was sort of my plan of attack, to decide those older motions first.
Okay, that's helpful to know. So it sounds like you may have gotten assigned some dogs when you arrived. It happens sometimes with the newly arrived judge. It's sort of a hazing ritual among some judges. Well, the reason I ask about the dispositive motion issue is that there's a natural tendency among judges, including federal district judges, to want to not face the more difficult decision whenever they can avoid it. It is more difficult to grant a motion for summary judgment than it is to deny one. And you're subject to appeal much more quickly, more likely to get reversed, and if you deny it, the parties might well settle and call that trial by attrition. It's a list of paradoxes that exist in the court, in the judicial system. On the one hand, justice delayed is justice denied. On the other hand, as evidenced by the turtles on display in the courtyards at the Supreme Court across the street. Sometimes the deliberative process needs to be deliberate, and it needs to be slow-paced. And so those tensions have to be managed. But the risk we run into is the judge looking for ways, perhaps, to minimize the judge's exposure to being overturned on appeal and the workload. Granting the motion for summary judgment requires you to write an opinion or order, which takes time and can be immediately appealed. Now, of these cases that you've got, I think it's 125 pending motions that you've got, ranking you as number 1 in the Seventh Circuit, number 7 in the nation. There are some that are troubling, some that, including one that was filed by a prisoner. This is not complex multi-district litigation involving huge mega corporations. There's one, for example, that's been fully briefed since November 2021, for 3.5 years nearly. We call this a fully ripe motion for summary judgment. The prisoner in this case filed the case complaining that he's, while in prison, suffering extreme tooth pain. It's apparently going unaddressed while he's in prison. They've done everything they can to get it teed up. It's fully briefed, it's before you, and just last month the plaintiff submitted another status report request of the court, and your response was, quote, "The court has taken defendant's motions under advisement and will endeavor to rule on both in the near future." What does that mean here, endeavor to rule? And what more would you need to rule on a case of that relative simplicity in less than 3.5 years?
Thank you, Senator. So do you happen to know the name of that case?
We can get that for you.
Okay. So there is a triage process that I follow in my chambers. We're generally working on the oldest motions, and I think reading what you just wrote, listening to what you just read to me, I think this means it's in the immediate pipeline, meaning that it's in the top, 10 things that are immediately going to be issued. Now, I am a very involved judge. I edit every single thing that goes out of my chambers, and so oftentimes and I go back and forth with my law clerks on drafts. It's not sometimes the most rapid process,
But does this case ring a bell? Do you recognize?
If I knew the name, it's probably, with all my law clerks, we have our list of things that we're working on, our pipeline, which has to be based somewhat on chronology. So you mentioned November 2021. I wasn't even on the bench yet. And so that came to me almost a year old. Right. And that wasn't even one of the oldest.
It was fully ripe before you became a judge. And
a year before I became a judge.
And I understand that sometimes new judges, part of this hazing ritual that I described, get assigned dogs, get assigned a long list of cases with pending dispositive motions. I understand that happens. But we will get that information to you. I raise it simply because it is very important that we not drag those out. At some point, it becomes trial by attrition, and the parties lose a lot when justice is delayed. Thank you, Mr. Chairman.